Hi, everyone. Good afternoon. Muy buenas tardes. I am truly honored to be invited by Professor Laura Velasquez to the Second International Congress on Private Law, Reconstructions and Prospects of Private Law here today to share with you the latest revisions to the corporate law of the People's Republic of China, which came into effect in 2024. I will share my screen with a PowerPoint. Yeah, so we can see here. Okay, my name is Elisa Wang. I am from Deheng, Shanghai Law Office. I am attorney at Law of People's Republic of China from Deheng, Shanghai Law Office. I am partner of Deheng, Shanghai Law Office and also head of Deheng, Mexico office to be set up very soon. Hope to see you there at the inauguration. Okay. Throughout my career, I have focused my practice primarily on international trade, overseas investment, and supply chain compliance, providing legal support for overseas investment to numerous state-owned enterprises, industrial leaders, and many Chinese companies in their top in their own business for their global investments. The revised corporate law marks one of the most significant upgrades on the field of corporate law in recent years, introducing major changes in capital system, corporate governance, and the duty of directors, supervisors, and senior management. Today, I am going to focus the corporate governance system under the revised Chinese corporate law. This section is divided into the 5 parts. The reforms of the capital contribution system, the board of directors single-tier governance structure, expansion of the board of directors' powers, change to the company resolution system, significance of the revision of the corporate law. First, as China's corporate law has undergone 3 major transformations over the past 3 decades. These measures are designed to ensure the governance practice such as transparency, accountability of directors, and protection of minority shareholders operate in tandem with the capital region. In a sense, the reform illustrates that capital structure and internal governance are 2 sides of the same coin. The way capital is raised and managed directly shaped the distribution of power and responsibility within the company. The optimization of governance structures is therefore a necessary complement to the modernization of the capital system, ensuring that flexibility in financing is matched with stronger oversight and integrity in corporate management. As we can see in this timeline, from 1993, the corporate law was first implemented in China, establishing a system that requires companies to register with a fully paid up statutory capital. In 2005, the law was revised to relax registration requirements, allowing registered capital to contribute to installments payments rather than being fully paid at the time of registration. In 2013, the registered capital system was fully reformed to a subscription system, abolishing the minimum registered capital requirement, the initial installment payment ratio, and the restrictions on the proportion of monetary contributions. And in 2024, we now enter to what can be considered the 3.0 version of the capital system, which maintains the subscription model, but introduces more constraints as well as more flexible tools while maintaining the subscription system. And beyond the reforms to the capital system, the 2004 revision also brings important changes to the way companies are governed internally. This evolution reflects the gradual shift of China's capital system from rigid statutory requirements toward a more flexible, market-oriented framework. The 2024 reform, in particular, seeks to strike a balance between flexibility and accountability, ensuring that companies enjoy greater freedom in capital contributions while strengthening safeguards to promote sound corporate governance and market integrity. The optimization of the corporate governance system and the adjustment of the governance structure are mainly reflected in three aspects: the adoption of a board of directors single-tier governance structure, the expansion of the power and the board of directors, and changes to the company's resolution system, as it's shown in this PowerPoint. There are different articles that related referring to the 3 points of changes. And in part 2, the adoption of a board of directors single-tier governance structure. Let us first examine compare the changes to the board of directors single-tier governance structure under the new corporate law. A comparison of the original legal provisions shows that the old law mainly required limited liability companies and joint stock companies to maintain a minimum number of members on their supervisory board and the board of directors, which the focus placed on standardization and uniformity of corporate governance structures. The new provisions, however, emphasizes flexibility, allowing small scale, according to tax law, with an annual taxable sales amount subject to the VAT of less than 500,000 Chinese yuan can be considered as a small-scale company, or a joint stock limited company to omit the supervisory board and appoint only one supervisor, or even dispense with the supervisory board entirely with the anonymous consent of all shareholders. The new corporate law introduces new provisions on the establishment of audit committees. Limited liability companies, according to Article 69, may set up an audit committee within a board of directors to exercise the power of the supervisory board. If such committee is established, the company may choose not to establish a supervisory board or appoint a supervisor. Joint stock companies, according to Article 121, may also establish an audit committee under their Article of Association, provided that more than half of its members do not hold any other positions apart from directors. These changes are designed to adapt to the governance needs of companies of different types and sizes, providing more flexible organizational structure options to enhance corporate governance efficiency and reduce operational costs. For a small-scale company, according to Article 75, 83 128 and 133, the governance structure is simpler. A limited liability company may choose not to establish a board of directors and instead appoint only one director. It may omit the establishment of a supervisory board and appoint one or two supervisors, or with anonymous shareholders' consent, dispense with the supervisory board altogether. Similarly, small-scale joint stock company may operate without a board of directors and appoint only one director, and it may replace a supervisory board with a single supervisor. The revision of the provisions on the one-tier board governance structure aligns with the international trend toward a single-tier governance structure, moving from a mandatory two-tier governance structure, which is shareholders meeting, board of directors, and supervisory board, to a flexible alternative that allows company to retain or omit certain bodies. The core significance of this revision can be summarized in 3 points. First, reducing the burden on small companies and lowering compliance costs. Second, providing large companies with additional options by allowing them to replace the traditional supervisory board with a more professional audit committee. And third, replacing legal compulsion with shareholder autonomy to align governance mechanisms with commercial needs. Okay, part 3, the expansion of the board of directors' power. A comparison of the original legal text shows that old provisions mainly focus on clarifying the board of directors' responsibility to the shareholders' meeting. The new provisions retain most of the former content while simplifying and adjusting the board's power. They remove the power to formulate the company's annual financial budget plan and financial accounts plan, and amend other powers specified in the company's articles of association to other powers specified in the company's article of association or granted by the shareholders meeting, thereby further emphasizing the authorizing role of the shareholders meeting in relation to the board's power. The new provisions appear to remove some of the powers of the board of directors, but in fact they grant the board more power by adding the power that the shareholders meeting can grant to the board of directors. Additionally, the new provisions introduce special rules for the board of directors of joint stock company, clarifying the scope of application and the relationship with other provisions. This reflects the specific consideration and governance requirements of joint stock companies. Overall, while maintaining the stability of the board's core power, the new provision places greater emphasis on the flexibility and adaptability to meet the governance needs of different types of companies. Although the revision of these provisions appears to extend the scope of board of directors' power from limited liability companies to joint stock companies, its essence is to establish the principle of board of directors centric in Chinese corporate law. Whether the company is a limited liability company or a joint stock company, the board of directors becomes the core organ of management and operation, unless otherwise provided by law. Its main significance include the 3 points. First, the unification of the list of powers. Second, the establishment of a board-centric governance. And third, the establishment of flexible exceptions for small companies. In summary, Article 67 and 120 formally establish the board of directors as the central hub of company operations and management by unifying the list of powers, instituting a board-centric model, and creating flexible exceptions. This framework prevents shareholders from overstepping their authority while laying a solid foundation for the modernization of corporate governance in China. In the part 4, we will see the concern changes to the company resolution. The changes to the company resolution changes. As seen in the legal provision, the old framework mainly empowered the court at the company's request to require shareholder who filed a lawsuit to provide appropriate security. This aimed to prevent abuse of litigation right by the shareholders, therefore avoiding causing unnecessary harm to the company. The new provisions extend to the time limit of shareholders who were not properly notified of a shareholders' meeting to exercise their right of rescission. This change provided minority shareholders a clearer legal basis to defend their legitimate rights and interests when excluded from the decision-making process. At the same time, the time limit ensures that such rights are exercised within a reasonable period, preventing uncertainty from dragging on too long and helping to prevent both the stability of company resolution and the efficiency of corporate governance. In this way, the mechanism protects the minority shareholders while also reducing the risk that the right of revocation could be used to unduly disrupt normal company operations. Regarding the comparison between the old and new provisions on the invalidity of companies' resolutions, the new provisions simplify and clarify the circumstances under which the resolution is deemed invalid, making them more straightforward to understand and apply. In addition, there is no longer a need to initiate separate litigations to declare a resolution invalid, which improves judicial efficiency and reduces costs on the parties involved. As illustrated in the figures below here, the new provisions clearly distinguish between 3 types of defective resolutions: null and void, be cancelled, and confirmed to be invalid, and their responding remedies. For null and void, content violates laws and administrative regulations. Be cancelled, which is procedural defects or unlawful voting methods with a 30-day deadline for filing a lawsuit. And for confirmed to be invalid, which is failure to meet the condition of validity. A lawsuit to revoke a shareholders' meeting or board of directors resolution refers to a claim period by shareholders or directors requesting the court to revoke a resolution on the ground that the resolution violates laws, regulations, or the company's article of association in terms of meeting procedures, voting methods, or content. However, this does not apply when procedure or voting irregularity are only minor and do not materially affect the resolution. Shareholders must file the lawsuit within 60 days from the resolution being made or within 60 days from the date when those who were not notified of the meeting became aware or should have become aware of the resolution. If the right to revoke is not exercised within 1 year from the date the resolution was made, the right to revoke is extinguished. Overall, the new provision aimed to enhance the efficiency and flexibility of the company's resolution system while safeguarding the legal rights and interests of shareholders and clarifying the legal consequences of a resolution being invalid, revoked, or deemed not to have been made. These changes to the provisions on the company's resolution system enhance corporate governance efficiency, reduce uncertainty, promote internal autonomy while within companies, and support corporate stability in company operation, while also erasing the burden on the judicial system. Okay, part 5, overall significance of the revision of the corporate law. The revision of the new corporate law introduces major adjustments and optimizations to China's corporate governance framework, carrying far-reaching significance. First, the introduction of the single-tier board of directors governance structure, the abolition of the supervisory board, and the establishment of an audit committee simplify internal governance, reduce decision-making levels, improve efficiency in the decision-making process, lower governance costs, and clarify the allocation of responsibility. These changes also strengthen accountability among board members, enabling them to fulfill their duties more effectively. Second, the expansion of the board of directors' powers allows it to exercise more comprehensive control over company operation and strategic planning. This reinforces its central role in corporate governance, enhances operational efficiency, improves adaptability to market changes, and promote the modernization of corporate governance, guiding it toward a more significant and balanced structure. Finally, the amendments to the company resolution system further standardize the company's internal decision-making process by clarifying the scope of authority, resolution procedure, and voting rules of both the shareholders' meeting and the board of directors. This safeguards the rights and interests of all shareholders, especially minority shareholders, improves transparency, fostering a more coherent governance structure. In return, it contributes to building a more significant and reasonable governance mechanism, thereby strengthening the overall effectiveness of corporate governance and laying a solid foundation for the company's healthy development and competitiveness. In summary, the new corporate law represents an important step towards the China's corporate governance system and carries significant implication for improving modern enterprise system and promoting high-quality economic development. And thanks again, muchas gracias for invitation and attention. This is a picture of my office in Shanghai. While I'm recording the video, I was watching what is on the picture. I look forward to receive your visit to Shanghai and also meet you in Mexico. Thank you. Bye-bye.